your turn. Let's talk.
And now, Hard Facts. Hard Facts with Dayo.
You're welcome back. Still Hard Facts at 92.3 Nigeria Info here in Port Harcourt. I'm Dayo. 11 minutes gone past 4 p.m. and the conversation continues at this time. I appreciate you staying tuned once again. Now, here's the story or the matter we're discussing at this time. We're going with the version as published by the Premium Times. VAT collection tussle. What appeal court ruling means, that's according to lawyers. Now, lawyers expressed their views on what the status quo, which the Court of Appeal ordered, should be maintained, means for VAT collections. Lawyers have expressed mixed reactions to Friday's ruling of the Court of Appeal in Abuja, which ordered parties to the value-added tax collection dispute to maintain status quo ante bellum. The Federal High Court in Port Harcourt, Rivers State Capital, had in a judgment declared that the Federal Inland Revenue Service had no constitutional backing to collect VAT in the state, thereby clothing the Rivers State government with the power to do so. However, the Federal Revenue Agency was dissatisfied with the trial court's verdict and subsequently approached the Court of Appeal to stay execution of the decision. A three-member panel of the Appellate Court ruling on the application ordered the parties to maintain status quo ante bellum. Haruna Tsunami, the judge who delivered the lead ruling of the panel, held that since parties had submitted themselves to the jurisdiction of the court for adjudication on the matter, they must not do anything that will destroy the subject matter of the appeal. The suit was then fixed for 16 September 2021 for hearing of an application by the Lagos State government to join the suit. FIRS and its appeal is praying the court to set aside the judgment of the Federal High Court in Port Harcourt, which granted power to the state government to collect VAT. And since Friday's, lawyers have expressed divergent views on the implication of the Court of Appeal ruling ordering parties to maintain status quo ante bellum. What exactly happened in court that day? Is there any confusion? Is there any ambiguity to it? And what is the impact on the situation? What is the status quo, if I may put it that way, at the moment of the subject matter of VAT collection in the country? These and other matters we're addressing now. Joining me in the studio for this conversation is Barrister Festus Ogwuche. Barrister, good evening to you. Welcome to the show.
Thank you, Dayo.
Thanks. Thank you always for being here.
Yes.
Let's get straight to it then. What exactly happened in court on Friday at the appeal court?
Well, first of all, my initial doubts were predicated on the fact that this is an appeal that was generated in the Port Harcourt division of the Federal Court of Appeal. All of a sudden, we heard that the matter is pending at the Court of Appeal in Abuja, and that raised a lot of curiosity. It evoked my curiosity to find out what exactly happened.
Why?
Along the line.
Why does that raise any curiosity?
Well, it's generated here, but I got to realize also that it's vacation period, and the vacation court is sitting at Abuja. And they said urgent matters must be heard. But I still find it difficult to rummage through the urgency of the whole matter, because the appeals are heard at the division where they are generated, where the appeals are filed. The appeal was filed here in the Port Harcourt division. But that is by the way. What happened was that Lagos State had filed an application to be joined as a part in that suit, and the counsel to FIRS had said that he had not responded, they had not received it, and maybe he should be allowed time to respond to it. And along the line, he asked that he did be given. At the same time, he was asking the court that the court should order the parties to maintain the status quo ante bellum. Arguments were canvassed in that direction, and all of a sudden, the court on its own granted the application for stay of execution. So the argument on ante bellum that I'm seeing on the mainstream media is not very correct. I have it on very good authority that what happened in court is that the court granted, in the interim, a stay of execution. And I'm just wondering whether that can be possible, or the court has the jurisdiction where they can grant an application, an order of that nature, where the application itself is pending for it are yet to be determined, and the parties are yet to even canvass issues or file their counter affidavit. But that's exactly what happened, and it was granted.
Can an appeal court hear an application for a stay of execution?
Yes, The normal procedure is that, first of all, after the judgment, the appellant has a right, upon filing an appeal, to come to the trial court, the court that delivered the judgment initially, for an application for a self-execution. If it is refused, you go to the appeal court, with the same application, not as an appellate issue, but within the appeal itself. And the court will look at it, and the parties have their 7 days to file their counter affidavit, their opposition to the application if they may. But I know that the issue of the motion for stay of execution was determined by the Honorable Justice Barr of the Federal High Court here in Port Harcourt on Monday last week. And as at Thursday, when the matter was before the Court of Appeal, the 7 days that required for the respondents to respond or react to the application was yet to be exhausted. So ordinarily the court couldn't have gone into the issue of the application itself. And also, as Lagos State had come in, and the court in its wisdom said, well, let's join Lagos State in the first place, and see how whatever order we make will bind all the parties. And along the line, the party, the council representing the Federal Inland Revenue Service, chose to apply that the status quo ante bellum be maintained, whatever that means. But along the line, in the course of arguments were canvassed on both sides on the propriety of granting an oral application in the interim in that manner. But along the line, the court on its own granted them the order for stay of execution of the judgment.
What's unusual about that?
It's unusual because parties were not heard on the application, and the application granted, the order granted is the same subject matter of the application for stay, which is yet to be determined. It's a little bizarre, because there's a pending application asking for stay of execution. Before hearing that application, before determining it, before taking counsel's argument on it, before the other parties can file their counter affidavit, you grant a motion and another for stay of execution. You make another for stay of execution. I think it's rather a little bizarre. It's unknown in our jurisprudence. Maybe the court may have better wisdom, but I don't think there's any precedence for that within the annals of Nigerian law yet.
I'd like for you to explain these two concepts or technical or legal terms, and if they are the same, and what exactly played out there. That's the matter of stay of execution and status quo ante bellum. Now, are they the same thing? Are they different? And which exactly played out in this case?
They're not the same thing. Status quo ante bellum means that maybe you go back to the status of the matter, the state of affairs of the matter, prior to the filing of proceedings, prior to the initiation of action. That's status quo ante bellum. Stay of proceedings is at least stay the judgment of this court, the instruments of that judgment, the facts of that judgment, the ratio of that judgment. Please stay its execution for now until this matter is determined, until this appeal is determined. And there's already a pending application filed by the Federal Inland Revenue Service asking for stay of execution pending appeal. But the order made by the court is saying that the execution be stayed pending the determination of the application for another stay of execution. So which one is substantive now? In other words, the court is granting the application for stay prior to the hearing of and determination of the application for stay itself. And I think maybe the court has better wisdom as to why it did it, but I don't think it is the appropriate thing to do in the circumstance. It's my own opinion. Anyway.
Of course. Now, so let's go on table, like you said, means go back to the way things were prior to whatever judgment of a trial court. Stay execution means don't implement. I'm still wondering here, Mr. Laws, how is it different? For me, because it simply means, even though this new judgment is going to alter the process, alter proceedings going forward, don't implement it. So how is that different from go back to the way things were before the trial proceeding?
It's quite different, though. It is very, very different. And in the case of a stay of execution, you're referring to the terms of that judgment, the tenor of that judgment. Status quo ante bellum is like nothing has ever happened. The court never gave any judgment.
So in this case, you're saying that the appeal court did not order that party maintains status quo ante bellum. That wasn't
the order. I have it on very good authority. The order made by the court is a stay of execution of the judgment of the Federal High Court. So
besides what may be the irregularities in granting that stay of execution, what is the implication for the matter of VAT collection?
The implication is that, well, the judgments cannot be implemented yet. it cannot be executed. To the extent that I understand the terms of that judgment, the subject matter of that judgment cannot be a subject matter of execution until the determination of the application for stay itself.
So who collects VAT now?
It doesn't even go to the issue of VAT, because...
But if the order of court granting that River State government has the right to collect VAT, and the appeal court has stayed the execution of that judgment, who does that? I think that might automatically mean that the FIRS should resume collection of VAT.
No. Look at it from the circumstances of the case. First of all, before the FIRS proceeded to the Court of Appeal to appeal that judgment, the Rivers State House of Assembly had proceeded pursuant to its constitutional powers to make law for VAT. It has exceeded that position because there's an existing law. An application for stay cannot stop the operation of law. An application for stay also cannot nullify the law at that stage, because in the first place, the law is not even subject matter of the judgment passed by the Federal High Court. A matter has to be subject matter of the judgment, which is appealed before the Court of Appeal can exercise jurisdiction on it and to order for stay and other things like that, stay of execution or stay of proceedings. The issue of the law is not there. And the order of the stay cannot nullify that law. And again, the substance of that judgment at the Federal High Court is to discountenance the power of the federal government to collect VAT. And in this sense, it means that the federal VAT law is already discountenanced on the grounds of unconstitutionality. The order for stay cannot resuscitate that law at all. In the first place, well, if you want to challenge the law of the River State on VAT, of course, that is the existing law when it comes to the subject matter. Or you have to start a new process altogether, because it is an existing law with provisions that have effect. So, in effect, the law stands. The River State law stands.
So, what was the appeal court staying then precisely?
Well, that's why I think I'm being very careful here so that we don't go into the nitty-gritty of the substantive appeal, because it is sub judice. But you now ask yourself, what is it saying? There's nothing to stay as far as I'm concerned. Are you talking about maybe stay? No. Because if you really go into the application for stay, then it's determining an interlocutory matter at the substantive stage. Because I took a look at what the FIRS filed, and probably I think the proper thing is to go into the substantive issues and determine the case substantively, in its entirety.
Yeah, but in the interim, a lot would have happened. The VAT would have been collected by the River State government. Doesn't that have such far-reaching consequences that would warrant a court to say, you know what, stay execution?
Yes, and I think what ought to have been done is that the parties maybe maintain the status quo in the interest of peace, in the interest of tranquility, and let all the parties withdraw their swords this time that the matter is before us. That can be agreed upon, but not on the basis of law. If you place it on the predication of law, of course, there's nothing stopping the River State government from going ahead to collect VAT.
So, technically, or are you saying legally at the moment, the River State government still has the right to go ahead to collect VAT?
Exactly, so long as that law subsists. So long as the judgment of the Federal High Court subsists and it has not been set aside. Because it requires it being set aside before the federal law on VAT could be resuscitated, because it's already dead on the basis of unconstitutionality. So now, what is the existing position of the law? The position of the law is the law that is existing. That order for stay cannot nullify that law.
So we have two elephants right now, the River State government and the FIRS, the federal government, slugging it out. What then happens to the grass right now? That is the businesses, corporations, organizations who are expected to pay this VAT.
What happens is that they fold their hands and watch the gladiators do the battle. At the end of the day, the winner takes it all.
But they have to pay VAT.
Well, they won't pay VAT for now, except if the River State government goes ahead and demands for VAT, they necessarily have to pay to the River State government, not to the FIRS.
Remarkable times indeed. We'll go for a commercial break. We'll return in a moment. Conversation will continue. You're welcome to join in via the usual platforms. Deeply stay with us. How to Fact returns shortly.
Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3 Nigeria Info. Visit our downtown office at Shop 9, Mediatrix of All Gracies Plaza, opposite FIRS, Stadium Road, Port Harcourt, and book your commercials. Call 0817 001 8162. That is 0817 001 8162. And let us connect you to your customers. Connect with your customers. Advertise on 92.3.
And now, Hard Facts. Hard Facts with Dio.
Welcome back. Still Hard Facts 92.3 Nigeria Info and Heron Port Harcourt. I'm Dio. 29 going past 4 p.m. Conversation continues. Thanks for staying tuned. The matter of discourse once again. Story cuts at Premium Times. VAT collection tussle. What appeal court ruling means. Lawyers have expressed mixed reactions to Friday's ruling of the Court of Appeal in Abuja, which ordered parties to the value-added tax collection dispute to maintain status quo in Tebelon. My guest in the studio joining me for this conversation is Barrister Festus Ogwuche. Barrister Ogwuche, welcome once again.
Yeah, thanks once again.
You do insist, however, that contrary to what the papers are publishing, that the court did not order that the parties maintain status quo in Tebelon, but rather it was a stay of execution order.
Yes, originally that was the application put forward by the Council to the Federal Inland Revenue Service, and the arguments were taken on it very, very seriously. There was serious opposition on the side of the River State government on the application made by Council to the FIRS, and later the court went and gave an order for stay of execution. I have it on a proper authority. That's what the court did.
I'd like to get your take on the thoughts of some lawyers that were expressed on the matters published by Premium Times. Starting with Curtis Adedayo, a constitutional lawyer and public affairs commentator. He expressed some concern what he termed, or he wondered why a court in Nigeria engaged in what he termed constructive ambiguity, which left the public and even parties in a legal quandary. He explained, quote, "The court gives you a judgment and you're left struggling to understand what it means." Is that a trend in our judicial procedure these days, and can one say that's playing out in this matter as well?
No, the court cannot give any order in vain. The order of court must be effective, and notwithstanding that the court may have given it without jurisdiction, or maybe the order is not executable, or the order cannot be executed or implemented. It doesn't matter. What is important is that parties must respect the order of court. But if there's any ambiguity respecting that order, then maybe it's to report to court and tell the court, well, this, for this and that reason, it cannot work. Like in this situation, I doubt if the court will fail to understand, for instance, that there's an existing law which must be implemented, being the fact that it has within its extant provisions that must be implemented, and the court has a duty to recognize the existence of such law. And for the fact that the law exists, the order for stay cannot affect it in any way. In any way, except probably the court just threw it in as a kite to get the parties to sheath their swords in the interim until the appeal is determined by it.
Talking about getting the sides to sheath their swords, Kayode Ajolo, a lawyer, said it was elementary position in law that when it matters before the court, parties are supposed to hold on in order to preserve the subject matter.
No, that is not the law. When the matter is before the court and the relevant instruments or processes or orders of court are not there to stop the execution of that judgment, the judgment creditor is always allowed to get the fruits of his judgment, to reap the fruits of his judgment. So, except if a court gives an order for stay of execution, the judgment creditor in the lower court or in the trial courts has a right to have the judgment implemented in his favor. So the filing of an appeal simply does not amount to a stay of execution of the judgment. No. I think that's a jurisprudence that's global. It's worldwide. So it's not something that maybe is peculiar to our own jurisdiction.
Also, our senior advocate of Nigeria, Ebmolu Adegboruwa, expressed an opinion on the matter as well. And he said, on analyzing the Court of Appeals ruling, Adegboruwa said the appellate court cannot stay the execution of a declaratory judgment of a lower court.
Exactly, I was going to that point.
And still quoting him, he said the judgment of the Federal High Court in Port Harcourt was declaratory.
All declaratory.
It only declared the right of Rivers State to collect VAT. No order was made.
Exactly.
Although the appellate court cannot stay the execution of a judgment that only declared rights.
I agree with him wholeheartedly. I was coming to that point because if you look at the judgment of the Federal High Court, there's nothing that substantively orders anything. It's just declaration vis-a-vis the provisions of the Constitution in terms of the constitutionality or otherwise of the federal government to collect VAT in view of items 58 and 59 of the exclusive legislative list. Those issues are very, very straightforward. And being declaratory in itself, a declaratory judgment cannot be implemented. It cannot be enforced. It cannot be executed. It's got a series, avalanche of judicial authority bear this fact out. So that's a very, very good submission by counsel, and I very much agree with him wholeheartedly, and that is the position of the law. So the stay which the Court of Appeal had ordered targets to no one, targets to no substance, target to nobody.
You're welcome to join the conversation right now. Lines are officially open to call 0817 93 0002, 0817 93 0003, and 0817 93 0007. We are live on facebook.com/Nigeria Info PH. Join the conversation thereon. Also live on YouTube. Search for Nigeria Info PH. And the WhatsApp is on 0809 0306416. Once again, via WhatsApp on 0809 030 6416. Via Facebook, Cosmos Udemet goes, I don't understand why the controversy and conflict. What does the Nigerian Constitution say in this? I think the Constitution should be the final say in this matter. Please let the lawyer explain what the Constitution says. Cosmos, I hope you're listening and possibly watching us via Facebook. My guest, Barrister Ogwuche, is doing justice to the subject matter at the moment. To the phone lines, I've got Andy from Wimbledon. Andy, hello, you're welcome. Go ahead.
Good evening, and good evening to your guest.
Go ahead, please.
Yeah, Dayo, I want to ask a question. One, your guest has said it all, but I want to ask, let him tell us the difference between an elected governor who has been taken to the court, and at the end of the day, he loses at the tribunal and he appeals, and at the end of the day, he is still there. What is different between this one and this other one as per the VAT? And secondly, too, don't he think the Rivers State government should stay clear for now, not collect any VAT? Because what we are talking about is the companies that are supposed to pay this VAT. At the end of the day, after paying, nobody knows what's going to happen at the Supreme Court. So don't you think for now, for the sake of the people and the company people that are supposed to pay this, don't you think the Rivers State government should stay clear for now? Thank you very much.
All right, Forrester.
Yes, it's a different scenario, totally different kettle of fish if you're looking at the issue of appeals and staying from the light or in the light of the Electoral Act. That's a different thing altogether, that a sitting governor could lose his case at the tribunal. He stays there because he has filed an appeal. He could continue to stay there because he lost at the Court of Appeal and he has filed another appeal in the Supreme Court. So it's like that. I think that aspect is peculiar to the electoral law, the election system, and it cannot apply in ordinary cases as this. So once a court delivers a judgment, that judgment becomes effective immediately and it becomes implementable.
Oh.
That is it. Then there's this other issue raised about.
He says, why shouldn't the River State government just take a chill pill and wait until the matter concludes?
No. It's a matter of wisdom. If they want to take that option, it behoves on them to take the appropriate steps, maybe to sheathe their swords, like I said earlier on. But there's something compelling them on that law not to collect VAT. In view of the circumstances, I say that, well, that order for stay of execution, except somebody proves it otherwise, cannot affect an existing law. The order for stay of execution of a court of competence cannot affect the validity or otherwise of an existing law. It has to go into the substantive issues. And I think that's the angle the court may take, without trying to delve into the nitty-gritty of the substantive issues. I would say that at the end of it, because even if the court makes that order that will affect the law, it goes into the substantive issues. And that was exactly why the Federal High Court refused the same application, because it said that means that I am already overruling myself in the substantive judgments, in the areas that I give judgment.
All right. We've got Emmanuel on the line from now 3. Emmanuel, you're welcome. Go ahead.
Hello, good evening, my brother.
Straight to your comment to question, please.
I want to ask this question. This case of appeal court of this self-execution and the case of PDP chairman are taken by local government and PDP. The court is saying secondaries without secondaries are not appear and making decision. What are different? Is it different thing or a similar case like that?
It's a totally different.
Emmanuel, so maybe some other time we will discuss the matter of the PDP. We'll take that up, but not today. Good to hear from you, though. Ikechi from Garrison, call back if you can. Once again, number to call 0817 93 0002 or 0003 or 0007. WhatsApp is on 0809 0306416. Once again, 0809 0306416. A reminder that also we are live on facebook.com /Nigeria Info PH. That's facebook.com /Nigeria Info PH. And let's see, do I have any comments via WhatsApp? Okay, we'll get to that in a moment. But Chooks Johns from Rukboko. Hello, Chooks, you're welcome. Please go on.
Yes. Besides the judgment being a declaratory one, the power of the government to collect VAT is not as it is now, based on the judgment of the Federal High Court, but based on the VAT law of Rivers State, which was made, at the time it was made, lawfully by the House of Assembly with the legislative competence to make that law by virtue of the judgment of the Federal High Court, which judgment was very valid as at then. So the Rivers State government can collect tax. The status quo and to use the Rivers State government to collect tax, not on the Federal High Court law, but on the Rivers State VAT law that you see valid and substantial, which is not a subject of any litigation in any court. So the Court of Appeal just made a statement, parties to maintain status quo. So the interpretation that is being the problem, not necessarily what the Court of Appeal said. parties to maintain status quo is naturally what should be happening in the matter. But the fact that the judgment is a declaratory one and that you cannot stay a declaratory judgment, the Rivers State government can and will collect the VAT based on the VAT law that is not subject of any appeal or any litigation at all. That's my take on it. And I support the submission of the council in the office.
Chuck's good to hear from you via WhatsApp. Is there an existing law in Nigerian constitution for FIRS to collect tax from states? That's from John Promise.
There's no existing law in the constitution asking any of the tiers of government to collect VAT. The court had determined it, and it's for the Court of Appeal to go into determining whether it can be implied that by virtue of the fact that there's no item like VAT in both the exclusive legislative lists and the concurrent list, either the states or the federal government can make legislation to that effect. And talking about it, we'll go into the nitty-gritty of the substantive facts, the issues, and the matter is sub judice, so we cannot preempt the Court of Appeal in its decision. But then we should understand that there's a remarkable difference between status quo and status quo antebellum.
All right. Similar to the question asked about the electoral situation, the question here from Mac Paul. Hello there, and barrister. Considering the law allows for court process to go through its entire course, can we say Rivers and State and Lagos moves too quickly to execute the judgment from a state high court? Can the action be likened to executing a man on death row before his appeal is heard?
It's a different scenario altogether. But, well, the thing is that it's not a man on death row, and circumstances has arisen to the fact that a man on death row has a right of appeal because he has to do it live. You cannot place it or juxtapose it with this kind of situation. This one has to do with collection of taxes. It includes money and a lot of other variables that has to do with the financial buoyancy of either the state government or the federal government, and to that effect, it is not something that you should wait for you to go through the entire hog of litigation. And in that circumstance, you have the other party trying as much as possible to slow down the process so that you can continue to collect it. It's not that. I think law has a lot of variables, a lot of dynamics, and it takes care of every situation, just like the gentleman who raised the issue of the electoral process, where a sitting governor will continue to sit in spite of the fact that he had filed a notice of appeal. Is simply the wisdom that you cannot begin to change governors along the line until the final decision is made. There is still need for serious reforms in the electoral system, and is to bring it in tandem with modern democratic practices.
Emeka from Emeka is going to call back if you can, please. So via WhatsApp, was there no law in Rivers State when FIRS was collecting VAT? Well, I think the very straightforward, simple answer to the question is yes. There was no law, either in the constitution or any enacted by the Rivers State government.
Even the federal law that was operative then was not. It started operations since 1992 or thereabout, or 93. I'm not sure now. So it's one of the inheritances of the laws of the Federation, which we now supposed to be an enactment of the National Assembly. So the idea of collection of VAT is one of the vestiges, or traditions we got from the military government, and which is now becoming a very serious issue of controversy all over.
Via WhatsApp, if there's ambiguity, why wouldn't the parties seek for interpretation of the judgment or ruling? General Justice said that. Do you think that's something the
there's
parties
no ambiguity whatsoever? I mean, it's very, very, very straightforward. It's unambiguous. It's straightforward. Because what we are saying is that the order of court for stay of execution, or even for the antebellum, status quo antebellum, cannot stop the operation of an existing law, nor resuscitate a law that's already been nullified by a court of competence. It cannot in any way. There's no way to operate. So to get that law nullified, or to make it ineffectual or ineffective, you have to go to a separate court to have it nullified on the basis that it is either unconstitutional or it is something else, because it is an existing law. And the issue of the law was not part of the judgment, the locus, the judgment of the court, of the Federal High Court in Port Harcourt. And so it cannot even be determined by the Court of Appeal.
All right, back to the field lines, I hope. Chris from Rumubiakana, you're welcome. Go ahead.
Yeah, good evening, Dayo.
Hello, Chris. Go ahead, please.
Yeah. For me, I don't see the FIRS winning this case, except maybe the National Assembly will enact law overnight that will help them to push their case. Otherwise, I mean, the state have their law, and that is the law they will work on. So maybe what they are trying to do is just to delay this VAT thing, so that Rivers government will not collect the tax. But I don't see them winning the case. Thank you.
All right, Chris, great to hear from you as well. And via WhatsApp, down from what your learned guests say, not different from Ozekame's views, by the way, the much advocated restructuring might have begun, albeit unbelievably and unprecedentedly. This could also lead to a whole lot of changes, come challenges in our national polity. Kudos to you and your guest at Edu from Port Harcourt. Dayo, I'm happy. Okay. I'm happy with the explanation given by the Prof, although I'm not a supporter of Wike. Are you a Prof?
Far from it, I'm not a Prof.
I'm
only a lawyer and a communications expert.
I'm happy with the explanation, although not a supporter of Wike, but I'm happy with the explanation. The funny part here is that some lawyers who are in support of the opposition party will call and counter what is just explained to us. Listen and you will hear them display political loyalty now. Thank you, that's Mikechi. Right, Keji, we've still got some 13 minutes to go before 5 o'clock. The lines are still open though. You can also join via Facebook. Once again, at facebook.com/Nigeria Info PH. And back to WhatsApp. Dayo, good afternoon. Please ask a guest regarding the VAT issue. In view of the seeming inconsistencies in the decisions of our courts, what implications does this have on one, jurisprudence, to investment decisions of potential investors, legal image globally? That's Chidi Wood from Rupoku. Well, interesting, but you've explained that there is no
ambiguous.
There is no inconsistency. There's no ambiguity.
We are yet to do that, to see that. So my only doubt, which I told you initially, was the fact that the matter was heard in the Abuja division of the court. Though the Court of Appeal is one court, one single court. So in spite of the subdivisions, they are regarded as one court. But then I know that if an appeal is initiated in a particular division, it is determined within the division. The reason being that, well, of course, what happened is simply for the fact that the vacation court is in Abuja, and the state urgent matters be taken there. So though I strongly doubt if there's any urgency in that appeal. But having taken it there, we also look forward that there will be the prospects of its return as soon as the vacation is over to the Port Harcourt division for determination and adjudication.
You got Lawson on the line. Hello, Lawson. Straight to your comment to question.
Okay, Dayo, thank you. Let me firstly appreciate the learned senior in the studio for explaining this seeming ambiguous position to the public. I mean, making it simple for the public to understand the nitty-gritty of what is involved in this old quagmire. However, the other side of it is that the federal government have no chance in this. Why do I say this? They cannot even go back to amend the constitution. Because if they go back to amend the constitution, they will not be able to get the third majority of the state assembly. Because almost all the states are gearing up to this VAT. So I think it's like it's something that they cannot, in all fronts. Going to amend the constitution, they will not be able to get it. And with the provisions of the constitution, they will not be able to get it. So why prolong this thing? You are rather prolonging the good days for the state government. That's what I see it. Rather than this, all of this. But anyway, it's for the betterment for lawyers who will be briefed for this, all of this thing. Thank you.
All right, awesome. Great to hear from you as well. Good afternoon, Dial. Please, River State government should not relent. Other states should join. It's cheating, for God's sake. What kind of brothers keeper? Are we playing football here? That's from famous Felicia's. Also via WhatsApp, if the Constitution of Nigeria guides Nigerian courts that this VAT issue between the state government, Rivers, Lagos, etc., and the federal government should be guided by the Constitution. Let the parties, mostly the federal government, respect the Constitution by allowing state governments to collect VAT if the Nigerian Constitution says so. to the phone lines. Balco, hello, hard fact to welcome.
Yes, good afternoon.
Oh, go ahead.
Now, with the declaration of the lawyers that the VAT law from West is was not in contention, and the judgment by the Court of Appeal that parties should not do anything to give effect to the judgment of the Federal High Court. Did the Court of Appeal overreach itself? That's the question I want to ask the lawyer.
Okay. Right.
Overreach. I will be very cautious to say that the Court of Appeal overreached itself. It gave a decision and order that it thought to be appropriate in the circumstance. It's not that it overreached itself. At the appropriate time, it look at the order it made vis-a-vis the circumstances of the case, the facts of the case, and vis-a-vis the appeal and the grounds of appeal brought in. Now, we've not gotten to that stage. What we are discussing here is not the likely success or defeat in that case. We are not doing that analysis one bit. We are just trying to see things from the perspective of what happened in court. I think it was on Thursday or Friday. I can't remember. And the issue of the court overreaching itself does not arise at all.
Still in along the lines of the question of the last caller, and I think I may have mentioned this in the course of the conversation as well. So the appeal court has granted a stay of execution. A stay of execution of what?
A stay of execution of what? I don't know.
Doesn't that...
it cannot relate to that. Probably, probably there are other aspects of that judgment that does not touch on that, or maybe things that should wait until the Court of Appeal determines the motion for stay of execution, because that stay of execution was granted pending the determination of the application for stay of execution. For another stay of execution. So we keep our fingers crossed. At the end of the day, the parties are returning to court on the what date will they say, and once they return, the court will look at the substratum of the order it made and maybe tell us what it's talking about there.
Still, going by the plan.
But like I said, the court cannot make an order in vain.
Yeah, but staying what?
We are with the courts to clarify itself. Okay. We cannot sit here and clarify the courts.
All right, so back to WhatsApp. Hello there. Going by the planned move by FIRS to smuggle a bill to empower it to collect the said tax, if it is possible for the Constitution to be amended in favor of FIRS, would the State Assembly law still suffice, or will the amendment only be binding on the states where the federal government have jurisdiction? That's from Anthony. Did you get a question?
No, I didn't get it.
Okay, going by the planned move by FIRS to smuggle a bill to empower it to collect the said tax, if it is possible for the Constitution to be amended in favor of FIRS, will the State Assembly law still suffice?
Of course, it will not. It will not. But then it raises a lot of questions about our constitutionality and our brand of federalism. And the scenario is not just a matter, a contention between the federal government and the River State government and Lagos State government or the states. It's even behoves on the individuals, the companies themselves, to ask questions on whether VAT is allowable under the Constitution. Like in the United States of America, I think it's just one single state. The VAT is charged on spending and all those areas. It's not a federal law. It is very absurd, totally absurd to conceive that the federal government of the United States of America will go to Florida to collect tax on VAT, for instance. But then there's been serious opposition to the imposition of VAT as a taxable item within the United States of America, and see that only about a single or two states are collected VAT. So the people themselves have the power, the opportunity, to go to court to challenge whether if VAT is not contained in the exclusive list and the concurrent list, whereas the residual list, should VAT be collected either by the federal government or by the state government. So it's still an evolving scenario of constitutional interpretation, and that's why it calls for the astuteness of the judiciary, because the law is an instrument of social engineering. There have been a series of agitations and demands for resource control, decentralization, devolution of powers, and secession. And this is one single opportunity to settle all these cacophony of agitations and demands once and for all.
I think that would be an appropriate note for us to wrap up the conversation. We'll definitely keep an eye on the situation, and hopefully in the coming days we'll have the honour of your presence as to explore this matter some more.
Yes, of course.
Thanks for joining in, and especially thanks to my guest, Barrister Festus Ogwuche, for weighing in on the matter at hand. Many thanks for your time once again.
Thank you very much, Dayo.
Commercial break, and the news top of the hour, 5 p.m. After that, discussions continue on the former or sacked Julius Berger workers who have been declared wanted by the Rivers State government. Do please stay tuned. We'll be right back in a bit.